Hi, I'm FN. I have been following the Brooks trial in Wisconsin. It seems like a lot of people have been as well. I suspect that segments from this trial will be used as examples by pre-law and law school classes for years to come. So with that in mind, I thought I would give a short summary of hearsay. It's going to be short, and truthfully not a full lecture. It is more of a quick overview. But maybe it will help you. Let's take it to the chalkboard. Pay attention here, it's about to get educational. In law school, I was taught that hearsay is any out-of-court statement offered for the proof of the matter asserted. It is considered inadmissible unless it is supported by a hearsay exception. You should always consider whether the statement is being made in court or out of court, who the declarant is, and where the referenced statement took place. But what does that really mean? It's any statement, written or oral, that was made, while not in court under oath, that is being used to prove or support a fact. An example of this would be like, Alan tells Betty that Chad shot David. Now Betty is trying to testify as to what Alan told her. And it's being offered to prove that Chad shot David. That's hearsay, because Alan can be subpoenaed to testify and be cross-examined. Now if it's not being offered to prove the truth of the matter asserted, then it might be admissible under a hearsay exception. For example, if Alan tells Betty that David has been shot, and she goes rushing in to render aid, the statement that Alan made would not be hearsay, because it is offered to show only what Betty did next.
Be seated. Mr. Brooks, before I have you question this witness any further, it sounds like to me that you are attempting to offer through this witness the statements made by Mr. Lascano.
Now you can see how hearsay looks in a practical example. Brooks is trying to get this witness to testify to the truthfulness of something that he was told by a third person. That's hearsay. Now there could possibly be an exception, but I am not familiar with Wisconsin-specific law. We'll talk about exceptions later on in the video.
If that is what you are trying to do, you may not do that. You will have to call Mr. Lascano as a witness if you so choose, if he's on your witness list. But that your questions are seeking to elicit hearsay from this witness. That's why I had the jury removed so I could explain my ruling and why I'm going to direct you not to ask this witness questions about what Mr. Lascano may or may not have said.
I can't say enough good things about this judge. She has been remarkably patient with the shenanigans of Mr. Brooks. She is trying her level best to coach this witness on how court process works, and at least teach him where to look for the rules on hearsay. She can't literally teach him the law, that's not proper or permissible, but she can direct him where in the code to look, to educate himself. Because the defendant is acting pro se, she can be a little more lenient or lax in strictly enforcing the rules, like she would to a lawyer. You will notice that she frequently does things outside of the hearing of the jury. She is aware that by lecturing the defendant about how little he knows, she potentially could prejudice the jury. She is doing everything she can to make sure that the defendant gets a fair trial. Under the federal rules, and most states have similar provisions, the judge should conduct certain hearings so that the jury cannot hear or see it. 1. If the hearing involves the admissibility of a confession. Or 2. A defendant in a criminal case is a witness, and so requests. Or 3. Justice so requires. In this case, justice requires that the judge have many of the hearings on motions, so the jury doesn't see it, in order to preserve the defendant's right to a full and fair trial.
I'm reading directly from his report.
That would be double hearsay then, because it's not you need Mr. Lascano here to say what he told this officer. If you are attempting to offer it for the truth of the matter asserted, which is what I believe you are doing, you're attempting to establish the veracity of something Mr. Lascano either said or didn't say through another witness. That is hearsay.
Mr. Brooks is attempting to get this officer to testify to what Mr. Luscano told him. That's hearsay. Now there might be an exception, if Brooks is offering the testimony, only to show what the officer did next in his investigation. That is not for me to say, as that's legal advice. But Mr. Brooks would do himself a favor, and go back to his cell and learn the hearsay exceptions. The reason that this is hearsay, is that Mr. Luscano could be subpoenaed to testify, and would then be subjected to cross-examination.
So it's not hearsay for the prosecutor to bring up.
I'm not going to talk about other rulings. There's been an objection by the state, and I'm sustaining the objection, and I'm directing you not to ask this witness questions that would call for this witness to say what Mr. Luscano said. That is hearsay. That is textbook hearsay, Mr. Brooks.
Back when I was teaching undergraduate students law at the college, I was using video clips just like these to show real-world examples of the concepts I was teaching. This one is especially good because it illustrates hearsay to a T.
I don't think it's fair for me to object to hearsay from the prosecution about along the lines of the same type of thing.
I'm not going to have a debate on what may have come in previously. I know you've made a number of hearsay objections, many of which the answers that were being provided were not hearsay. But I would direct your attention to 908.01 of the Wisconsin statutes. You have that book in front of you that I provided to you a number of days ago at the beginning of this trial or near the beginning of this trial. There's the definitional section of the statutes which defines hearsay. It also, and then if you go on to 908.02, that's obviously one you may want to look at as well.
Obviously, Mr. Brooks does not understand what hearsay is. But again, the judge is trying to direct him to the proper place in the code, to educate himself. But Mr. Brooks is a sovereign citizen, and therefore believes that the rules don't apply to him. So he's not going to learn, and I fully expect that he'll continue to behave this way, for the remainder of the trial.
And then 90803 has the exception. So unless you can give me an exception, sir, as to why this witness should be allowed to answer those questions, I'm going to, again, direct you not to ask these questions. I'm reading
directly from his report, the report that he wrote. Nothing is coming from, I'm reading directly from his report. That's what I have in front of me.
Doesn't change the fact that it's hearsay.
You said what?
That doesn't change the fact that it's hearsay.
So his report is hearsay?
Another level of hearsay. It's an out-of-court statement.
So
not this witness made, but what another witness made. So you have to...
So I can't read from his report that he wrote?
You can't ask this witness questions that call for a hearsay answer unless there's no objection from the state. Or you can convince me there's an exception to the hearsay rule that applies. Do you have an exception you'd like to offer to the court?
So I might as well not read the report that he wrote then if I can't question him about the report that he wrote.
Tell him that there might be an exception, without telling him that there might be an exception. Honestly, he might not win, arguing the motion, but at least he'll learn them for the future. In the federal system, Rule 803 governs the exceptions to the hearsay rule. Each state has its own set of exceptions. However, if you have a good understanding of the federal rules, it is very easy to find something that is the same or similar in a state-specific rule. Also, once he reads and learns the rules, he might see that there could be another way to get the report, or testimony that says the same things as the report, into evidence.
That's your misunderstanding, sir, what is hearsay. And all I can tell you is I'm sustaining the objection. I'm going to bring the jury back out, and we'll go from there. All right, Madam Clerk, bring the jury out, please.
Clear bias. Clear bias.
Mr. Brooks, I understand you may disagree with
or agree to being called that name. For the record, again, I'm here as a third-party intervener on behalf of my client. I don't know why that's not understood by now.
When all else fails, fall back on the sovereign citizen script. The judge has been patient and indulged him, by saying that he is the living person that the court identifies as Mr. Brooks. If you've never seen what a sovereign citizen looks like, this trial will teach you everything you need to know. That's a very short and cursory overview of Hearsay. I hope you enjoyed this video. This is my first attempt using my new avatar. I'm sure things will improve in quality in the future. If you did enjoy it, please hit the like button and let me know what you think of the new video format in the comments section. Likes and comments really help with the algorithm. As always, thanks for watching.